Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. In this video, we are going to discuss an old decided case law on the Prevention of Atrocities on SC/ST Act 1989. All of you are well aware that the so-called SC/ST Act has almost replaced, I can say, the Protection of Civil Rights Act. Of course, that is also in force. It is a welfare act which is intended to protect the SC/ST people from the atrocities caused by the upper caste people. In this act, particularly section 3 is more important because it has given definition for about 18 offences which are likely to be committed by the upper caste people over SC/STs. 3.1.10 and 3.1.E are more frequently used. The important point here is, if the offence takes place in a place within public view, or should it take place in a public place? A place within public view or a public place? So what is the difference? Where it should occur, where then only the cognizance will be taken. This we are going to discuss in this celebrated case law. Hitesh Varma versus State of Uttarakhand. Hitesh Varma versus State of Uttarakhand. In criminal appeal number 707 by 2020, decided on 5/11/2020 by two justices, Justice Hemant Gupta and another judge, Ajay Rastogi. So while dealing with the case, all these topics have been discussed. Actually, this relates to crime number 173 by 2019, registered under sections 452 IPC, that is trespass into a house armed with deadly weapons, 504, 506, that is criminal intimidation, and section 3.1.C and 3.1.10 of the SC/ST Act 1989. This is the FIR registered. So as per the complaint, on 10/12/2019 at about 10 a.m., the accused Hitesh Varma and 4 others, they have trespassed or they have forcibly entered into the house of the victim and asked her not to go or not to go as a domestic helper to the complainant. And they abused the woman in her caste name. Please remember, they scolded her in the name of her caste and also gave her death threat. That means if you don't oblige or if you don't oblige to our command, will make you die. That means there is a death. They have given a death threat to her also. So based on the contents, we approached the police station, they registered the case, and they have arrested the accused under the above sections of law and they have filed the charge sheet also. Now the issue is, since the incident took place inside the house, whether the SC/ST Act is attracted or not. So please remember, according to section 3, it says, whoever intentionally, this is more important, intentionally insults or intimidates any member of the SC/ST community in any place within public view. This is important, within public view. What is this place within public view? And normally people may misunderstand it as public place. So please remember, public view, within public view means if there is any chance of the public to see the incident, even though they are outside, they may not be inside. If from outside, yes, it is a place within public view. Suppose if an offense is committed outside the building, please remember, or in the lawn, not in the house, it is committed outside the building, in the lawn particularly. If it is the place can be seen by someone outside the land, someone on the road, if it is visible to them, yes, it is a place within public view. Even though they are outside the boundary wall, if they see it, it is a place within public view. But if it is, you all know what is a public place. A public place is a place where everybody has got actually right to enter. So Here, in this particular case, what happened? The allegation is that these people and trespassed into her house or deliberately, they committed house trespass in her house and threatened her. Where the offense took place? Inside the house. When inside the house, it is only intimidation. 506, 504 or 452, but section 3110 or 31E will not be attracted because it is not a place within public view. So this is a very good judgment. You have to understand the difference between the public place and a place within public view. This was clearly stated in AP case also. Garige Pentaya versus State of AP 2000, I think it is in 2000. And another celebrated case, Singh versus State, that's all, 1994. And in 2018, Dr. Kashinath judgment, that is case law, Dr. Subhash Kashinath Mahajan, yes. Dr. Subhash Kashinath Mahajan versus State of Maharashtra 2018. All these case laws will come to your rescue if you feel that the offense took place outside the public view, in a place which is not within the public view. So, on the practical side, I want to tell an incident. When I was in Chirala, I think it happened. So, the municipal commissioner Chirala, it seems he has used or he has insulted the SC persons in his chamber. A case was registered on section 3110 or something like that. But in that case, you may be knowing, according to section 4, the SDPO, he has to take up action. The SP has given permission to me. I think, by that time, I SDPO, Chirala. So, I have investigated the case. I said it is not a place within public view. It occurred inside the chambers of the so-called municipal commissioner. Section 3110 will not acted. Lot of criticism, lot of resentment. Even the IG, PCR cell, he has also said, no. When some offense takes place, then there are witnesses. You have to charge the same. I said it's not possible. You can charge him under PCR, Protection of Civil Rights Act. But here, number one, there should be intention. There is no intention. He is a municipal commissioner. Some people came, they asked him to transfer or to convert the municipal TB, which is near the RTC bus stand, into Ambedkar Bhavan. Now it is done. At the time he did not agree. He says that there is a lot of procedure and you have to approach the concerned municipal minister like that. But they were annoyed with the attitude of the municipal commissioner, and of course, whether it is true or not, even though we have scolded them, the point is it cannot be an offense under section 3. The other sections will be there. Same thing happened in this case also. In this Hitesh Varma, Supreme Court allowed the appeal 482 actually. Appeal, and the Supreme Court stated that yes, the case can be proceeded with the other sections of law like 452, 504, but not section 3 of the SC/ST case. So this is what you have to learn. So there are all the three, Hitesh Varma, Singh, Dr. Kashinath Mahajan, and also Garige Pentaya. These 4 cases are very, very important cases if you oppose the SC/ST Act. So please remember them and enrich your legal knowledge. Thank you very much.